I will number the case today after docket and let you know after lunch
Yeah.
today. I do want to, it looks like there's been plea bargain rejection on file for some time. That was for a so Mr. Bell, if found guilty, we've gone over this before, you would be considered a habitual offender because of your prior criminal convictions. And the offer was for a 25-year term, which is the minimum for a habitual offender. And you have, again, every right to reject that and go forward with trial. Is that what you want to do?
Yes.
All right, we will,
Actually, I
again,
think the state had offered 20 in this case, Judge.
had you, there
Yeah.
might have been one that was fell off that maybe you didn't do a new
I
rejection.
think it was before the last trial docket. They dropped down to 20, but
Okay, so anything other than the 20 today?
no.
All right, so it would be a 20-year offer if you wanted to take that. Okay, we'll get it set for, I'll number the case after docket and let Mr. West know. Thank you.
He has a conviction.
There's two, there's an assault to third degree from September 11th of 2019 in the indictment. And then a prior one, attempted robbery, third degree, March 28th, 2013.
Yeah, I was looking at the unlawful possession of a firearm indictment. I don't know that both of those are priors were included in that particular.
No, it's not. It's not, Judge. It's just as one of them in that case. I looked at.
But if there are two, you would
Right.
file that notice.
would,
So
right.
it would be considered habitual, correct? Okay.
Eventually I will.
Okay. All right, so are you Kendrick O'Veal?
Yes, ma'am.
And Mr. O'Veal, in cause number 25 DCCR 1776. Sorry, it's taking. You are charged with evading arrest or detention with previous conviction, and that's from August 31st of 2025. That shows that you were previously convicted of evading arrest or detention July 22nd of 2011. So that's what makes it a state jail felony. Then the indictment further alleges you were convicted of attempted robbery, a third degree felony, March 28th of 2013. And after that was final, you were convicted of assault, a third degree felony, September 11th of 2019. And so what that means in that case is that if you go to trial and you're found guilty, and those prior convictions are true, the range of punishment would be enhanced to a second degree felony, which is between 2 years and up to 20 years. Do you understand?
Yeah.
And then in cause number 25 DCCR 1777, you're charged with unlawful possession of a firearm by felon. And that is from August 31st of 2025. That indictment alleges one prior felony conviction, the one from 2019, but the state can file, and I anticipate they would file a notice of enhancement because that 2013 was left off of that indictment. And so what that means in that case is if you're found guilty and if those prior convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years in prison up to 99 years or the rest of your life. Do you understand? And then finally, in cause number 25 DCCR 1778. Once we get all these done. You're charged with the third degree felony offense of deadly conduct discharging a firearm from that same date of August 31st of 2025. It does allege those two prior felony convictions. Again, what that means, if you're found guilty and if those prior convictions are true, you would be considered a habitual offender in that case also, with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
In all of those cases, I have here on this tablet a plea bargain rejection in each case that you've signed with Mr. Parker that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty in your cases, to go on, probably it looks like counts 1 and 2 for a 15-year term instead of that habitual. And so in 2 of the cases, a 15-year term, and then in
It's 15 on all, concurrent on all of them, Judge. Yeah, because at state jail is the edit.
I opened the wrong one. Sorry. hold on, y'all don't want me to do that. That's a 30.
Oh, that's my next one.
Sorry. Okay, so 15 years in all three cases that would run concurrently, which means together at the same time. Do you understand what the state has offered you? And so you have every right to reject that offer and have all three of your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty in your cases. And do you understand all of that? And do you want to reject those offers and have your cases set for trial? All right, we'll get that done. I do want to, is there any reason to believe that these offers would change?
Not at all, Judge.
So, Mr. Oville, I want to make sure you understand that after today, unless there is new evidence that is discovered by either your attorney or the state's attorney, I will not accept these plea agreements again. Once it's on the trial docket, it either goes to trial, you can plea open to the court or to some different amount or negotiated punishment. Do you understand? Okay, so I will get your cases set for trial. Mr. Oville, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and I can appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you? Okay, so Mr. Parker, you're released. Mr. Oville, we will appoint someone today. They should be out to see you very soon to begin preparation for trial.
Thank you.
Thank you. Good morning. Are you Howard Walker Jr.? And Mr. Walker, in cause number 26, DCCR 0082, you're charged with a first-degree felony offense of injury to a child from December 16th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the minimum punishment is 5 years, up to 99 years or life in prison. Do you understand? And I have here on the tablet a document called the plea bargain rejection.
This is where the stakes suddenly get much higher. The judge is about to explain how prior convictions can dramatically increase the possible sentence. In criminal court, a defendant's history can completely change the punishment range. Here's the big question. If you knew rejecting a plea could expose you to decades behind bars, would you still take your chances at trial? Let's see what happens next.
That has your signature on it with Mr. Parker's. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty in your case for a 30-year term in prison. You have every right to reject that, have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you want to enter a plea of guilty. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Nicholas, is there any reason to believe that, are you waiting on any evidence?
Judge, that offer is based on the injuries sustained by the child, a 1-year-old with facial fractures and lacerated liver. I need to get some follow-up medical records to see if that condition has improved or if it's going to be a permanent injury situation. That offer may get worse depending on what I find.
Okay, so I do want to make sure you understand, Mr. Walker, that after today, I will not accept this plea agreement unless there's some new evidence that comes to light from your attorney or the state's attorney. Do you understand?
Yes, ma'am.
All right. And so also, Mr. Parker's been appointed to represent you. And he's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, Mr. Parker, you're released. Mr. Walker, we will appoint someone today and they should be out to see you very soon to begin preparation for trial. All right, you can go back with the bailiff.